Welcome, everyone. Thanks for choosing to attend our breakout session today. Today, Chris and I are going to discuss 4 common purchase price payment methods. Bear with me, that's a bit of a tongue twister today, and the strategic considerations tied to each one. Then I'll turn it over to Chris, and he'll walk through a deep dive into one particular purchase price payment method of seller financing, including a discussion of seller notes, information rights and covenants in seller notes, and subordination terms. Questions are welcomed and encouraged throughout the presentation. Please raise your hand and we'll pause when natural for questions. By way of introduction, my name is Lindsay Neuens. I'm an associate attorney in Reinhart's corporate group. My practice is focused on mergers and acquisitions, particularly middle market transactions, and I also spend time providing day-to-day business consulting services to our clients.
And as Lindsay mentioned, I'm Chris Rechlicz. I'm a shareholder at Reinhart. I've been at the firm for about 23 years. Practice in our corporate group as well, so I do some general corporate work, but my practice is focused mostly on financing, traditional senior lender financing, private equity, mezzanine debt financing, capital leasing, real estate, and then for both borrowers and lenders. So work both sides of the transactions, and a big chunk of that is seller note financing on acquisitions.
I'm going to begin today's presentation by providing a basic overview of the most common purchase price structures that we see in M&A deals. So as you know, both parties will participate in the determination of purchase price structure, meaning how and when the purchase price will be paid by the buyer to the seller. When determining purchase price payment structure, the parties will consider their objectives, timing, and their appetites for risk. These discussions regarding purchase price structure will take place early in the process, and purchase price structure is typically a key feature of the negotiated letter of intent between the parties. However, as we probably learned during the initial panel discussions, the purchase price payment structure is subject to adjustments based on information learned during the due diligence process. The first purchase price payment method is cash. Cash payment is exactly what it sounds like. The buyer may pay the seller in cash at closing. It may be 100% of the purchase price paid in cash, or just a portion of it paid in cash at closing. The second method we're going to talk about today is rollover equity. Rollover equity is when a portion of the sales proceeds are paid in the form of a post-closing equity stake in the buyer entity, or one of its affiliates, which commonly ends up being the parent entity. Rather than a sale of all equity or assets of the seller, a portion of the transferred equity or assets in the amount of the rollover amount will be contributed to an entity on the buy side as an investment in such entity. The rollover amount is then deducted from the cash purchase price paid at closing. The third method of purchase price payment is seller financing. Seller financing involves the buyer issuing a promissory note to the seller for a portion of the payment price. I won't spend too much time discussing this method now because the second half of this presentation will focus on seller notes. Finally, the last method of paying the purchase price that we'll discuss today is an earnout. Some of the purchase price may be paid through an earnout. An earnout is when a portion of the purchase price of a business is contingent on the post-closing performance of the business. Oftentimes, earnouts are structured as one or more contingent payments after the closing, which are payable on the satisfaction of certain milestones, such as revenue and future sales targets. As we'll discuss, parties often use a combination of these various purchase price methods in various percentages. Now I'm going to turn to key factors and strategic considerations tied to each purchase payment method. There are pros and cons related to each method that will depend on your role in the transaction. For example, whether you're on the buy or sell side. First, and perhaps the most straightforward method, is the cash payment method. Of course, if this is a selected payment method, then the buyer must be prepared with liquid cash funds to provide to the seller at closing. As you can imagine, sellers typically tend to prefer this method, as it provides certainty in the amount of cash that it will receive for the business at closing, and there is no need for the seller to consider the future performance of the business. However, buyers should also consider the advantages of this certainty. The buyer knows exactly how much cash it will be spending on the business at closing. Another aspect to consider when using the cash payment method is that it provides a clean break for the parties. When there is a cash purchase price, there's really no financial incentive for the parties to continue working together after closing, which can be seen as either a negative or a positive for the parties, depending on their relationship and the future needs of the business. According to SRS's most recent deal term study, the use of an all-cash purchase price has decreased in recent years. In 2020, about 80% of deals were paid in all cash, but by 2023, only 58% were all cash. So we can see that this purchase price payment method's popularity is decreasing, at least in 100% capacity. Turning now to rollover equity. This approach is attractive for buyers because, of course, it reduces the amount of cash necessary for buyers to have on hand at closing. Rollover equity really incentivizes a team approach for deal parties as buyers and sellers share a common goal of post-closing success for the business. Buyers and sellers are both hoping that the new equity will appreciate in value and lead to greater returns in a future transaction or exit. In fact, this can sometimes be a determining factor when there's a competitive bidding process. Established buyers with already successful businesses may be able to bolster their positions or their bids with sellers by offering rollover equity to sellers as part of the deal package, offering the opportunity for a greater return in the future. It also encourages key employees to continue with the business and to continue investing in the future performance and success of the business, since they'll have a chance to participate in the future upside. From the buyer's perspective, this is also valuable, as key employees will be available and willing to serve as sources of knowledge on both the business and the industry as a whole. Additionally, the issuance of rollover equity is typically a good way for buyers to protect themselves from competitive risks posed by sellers after closing, as stockholder agreements, LLC agreements, operating agreements can be drafted to contain restrictive covenants that are binding on the seller so long as they hold that rollover equity. There are also potential tax benefits when rollover equity is part of the purchase price payment structure, as they can be structured so that the taxes on the rollover portion of the consideration are deferred. Finally, the last note on rollover equity is that it poses some risks for both buyers and sellers, as there is no guarantee for success. Sellers are taking a risk that their rollover equity may not end up being more valuable than additional cash that they could have received at closing, and they also face the risk of potential dilution after closing, depending on the post-closing ownership structure. Next, I'll discuss earnouts. Like rollover equity, earnouts reduce the cash that is necessary for buyer to have on hand at closing, which can be a great benefit. We often see earnouts used to bridge valuation gaps. This is when the parties can't agree on a purchase price. Earnouts are especially useful when a business has little operating history but significant growth potential. Specifically, if a seller knows that it has a new product or technology that may increase the business's profitability in the future, an earnout may be especially beneficial for them. We also see these used where a business operates in a volatile industry that can affect profitability. So buyers can use an earnout as a way to protect themselves from overpaying and to hedge some of that risk. Earnouts are becoming increasingly popular in purchase agreements, and in 2023, approximately 33% of deals included an earnout opportunity. As mentioned, earnouts lack certainty, as they are contingent on achieving certain post-closing targets and milestones. These milestones and methods of measurement are often heavily negotiated, and special attention should be paid to drafting those clauses. An attractive feature of an earnout is that they're highly customizable by the parties. From the buyer's perspective, they're a good strategic tool as they keep the seller parties engaged and invested in the future success of the business. One downfall to consider of earnouts is that they offer, unfortunately, a high potential for post-closing disputes between the parties.
And I'll just add one note. We'll talk more about subordination, but a lot of times the senior lender, if you're getting financing, is going to want to subordinate the earnout. So you've had a discussion, if you're the buyer, you've had a discussion with your seller about hitting these milestones, and it can be, we talked about emotion earlier, it can be difficult then to go back and say, oh, and by the way, in order for me to get the financing that I need you to agree to subordinate the earnout. So even if we hit all the milestones and you otherwise think you're entitled to payment, if we have a covenant default on our bank financing, you may not get that payment, or that payment might be deferred or delayed. And, you know, that can cause obviously some issues. Talk to your potential finance providers, because one of the answers might be, hey, if we're hitting these revenue targets, we almost can't be in covenant default, right? If we're hitting X number on the revenue side or the EBITDA side, we're going to hit our leverage ratios, we're going to hit our fixed charge coverage ratios. You really don't need to subordinate this payment because, you know, again, if we hit those numbers and we hit if we hit those milestones, we're going to be in covenant compliance with your bank. Nonetheless, some banks will still require it. So I suppose you could flip that argument back onto your potential seller and say, hey, the bank's requiring this, but don't worry, if we achieve your milestones for you to get the earnout, the bank won't have the opportunity to block your payment. So.
And this is a good segue into Chris's portion of the presentation. The last item I'll talk about is seller financing. Seller financing is similar to rollover equity and earnouts in that it also reduces the necessary cash at hand for buyer at closing. These offer the benefit of certainty for sellers as they involve an unconditional promise by the buyer to make future payments to the seller. Additionally, there are negotiated aspects of the transaction that are customizable by the parties. And with that, I'll turn it over to Chris so he can walk us through some of the key aspects used in seller financing.
Thanks. I guess any questions on that portion? And if there are questions, please feel free to interrupt me. I don't need to have a 10-minute gist or 15-minute straight talking. I appreciate questions. So first, just a point on seller note terms. Again, it's a promissory note issued by the buyer to the seller for a portion of the purchase price. They're pretty common, especially in the deals that we see. You know, if you think about if a bank's going to do 3.5 of EBITDA or 3, and your purchase price is a 5 multiple or a 6 multiple, if the buyer isn't providing all the equity, you've got to bridge that purchase price gap somehow. Institutional mezz debt's one way, but seller financing is another way. So I think we find seller financing fairly typical in the deals that we see. They're usually fixed rate deals. I went back and did a very unscientific poll of seller notes that I've recently worked on. Rates ranged anywhere from 5% on the low end, and those are a few years old, to 12% on the high end. We also see, especially some of our private equity buyers will offer the seller the opportunity to participate in their mezz, in their debt strip. So if they're going to put in 10 million of equity, 20 million of debt, and then there's going to be senior financing on top of that, they'll give the seller the same economic terms that they're earning on the 20%. Usually the trade-off there is the seller, it's like a participation interest. They get no voting rights, they get no say on it, they're just along for the economic ride. They don't sort of get to then pretend to be a lender where their vote is required to waive a covenant default or extend a maturity date, or, you know, but it's a nice trade-off. If there is going to be seller note, you will get that higher, potentially that higher return, and you're more aligned then with your buyer because, hey, you know, they want to get their coupon paid as well. So again, that rate varies. Yes.
One, say hi to my friend Tim Ritter.
Okay.
Two, are you seeing some of these seller notes more often in a smaller deal, a large deal, or really across the spectrum?
There are more smaller deals. You know, some of our bigger PE clients that can, you know, maybe leverage more, have more capital providers available to them, don't need it. But certainly family offices, smaller size deals, and again, we have some SBIC private equity clients. They almost always want there's probably a rollover component to the equity, but then they almost always want their seller to take some strip of the debt as well, just to keep them alive, because they do want management to roll, they want management to stay participating. It keeps them interested, right? Because again, they're a little bit tied, the seller's a little bit tied in the performance of the company to make sure they get paid. Again, that's the interest rate. A few points there. All of those can affect how deeply how much you're financing, how deeply you're subordinated, can all affect the interest rate. Also, payment mechanisms vary greatly in these notes. Some act more like mezz debt, where it's interest only for 4 years and with a bullet maturity, due at maturity. Others are amortizing, or there's a combination of both. Go interest only for the first year or two while the company is getting, the new company is getting back on the ground, getting able to service its bank debt. You're adjusting to, new ownership group, and then after you've proved that out for a year or two, we start amortizing the debt and having it. And then amortization can also be fully amortizing over some period of time, or you do like a 7-year amort on a 5-year maturity, so you've got then a balloon payment at maturity. Yes.
On the rate side, do you expect that the seller note rate is always going to be higher than the senior debt rate due to the subordination, or is there any opportunity, particularly if it's like a retiring owner, that the stability of just an interest rate that's better than what they would get investing in bonds
Yeah.
is sufficient for them?
That is sufficient. I mean, I don't, not every seller is thinking about it from I'm taking more risk because my debt is subordinated, therefore I should get a higher return. Again, and also too, if you're only financing a smaller portion of the purchase price, you say, well, maybe you view that as like, hey, this is really just an addition. Maybe it's more like an earn-out as opposed to real purchase price. So again, like I said, we've seen 5% rates in the last 3 or 4 years. That's sort of below SOFR plus whatever, in the market or prime.
Do you find often that the seller, if he takes a note, is left holding the bag where it just doesn't work out?
Well, if it doesn't work out, that might be the case. Yeah, and we can talk about this. We'll get into the subordination later, but yeah, generally the bank's going to get paid first. So, but if that's the case, the buyer's probably left holding the bag too, because they're not getting any of their equity. I mean, the seller note's still in front of the equity. So it's still in front of the buyer's return on their capital. So, if they're left holding the bag, it was a pretty bad, that deal just didn't work out. Yes.
When you talk about the subordination and then talking about trying to meet covenants, how successful have you ever been in convincing the senior lenders to modify their covenants so that the subordination is really more illusory than it would be? Because once the subordination is there, then you're just along for the ride. And can you successfully negotiate the covenants so that you won't have a subordination?
Not really. Yeah. I mean,
So the subordination just kills, it's just going to be along for the ride, someone's going to be along for the ride after that.
well, depending, potentially, yeah. I mean, there are some, and we'll get into this in a minute. There are triggers that a seller can hold to make the senior lender do some things, but sort of a front end, you can still get paid if you're in covenant, you're out of financial covenant compliance, or we're not going to test covenants. That's really a non-starter. A bank might get there. If you've got a few years of performance and you trip one covenant on 1 quarter test, yeah, there I've seen banks say, we're just going to waive this. We're going to pretend it never happened. Seller can keep getting paid. This was a one-time blip due to X. But usually you got to prove that out at the time of the covenant default. So, maturity dates on seller notes. Again, this is, if you can, it's important to think about this at the LOI stage if you're the buyer, because if you are going to subordinate, your senior lender is going to want the seller note to, at a minimum, be coterminous, but even better, 3-6 months after their maturity. So if you're getting bank financing for 5 years and you promise a 3-year seller note, you might have a bank say, well, I can't have $5 million of principal get paid out before, you know, we're providing you a $15 million term loan to finance this acquisition. I can't have this seller note come out before I'm paid. So you need to get them to go to 5 years. Or your bank might say, well, we'll keep the amortization, but we're going to mature in 2.5, so, or 2.75 years. So you thought you had a 5-year deal, now you don't. And so, and banks are all different on this. Some are, no matter what, our seller can't mature before us. Others take a different view on it. But, and again, maybe the subordination solved this. If the subordination agreement says you get regularly scheduled payments, but not your final principal payment, well, if your seller signs up for that, they've kind of agreed to whatever maturity your senior lender has, because if there's a default, the senior lender can shut off that final, you know, payment at maturity. So, but just, again, in terms of the emotion of the seller, oh, I thought I was going to be out, thought you were going to get me paid out in 3 years, and now you're telling me I need 5, or, you know, and if you can sort those out at your LOI stage, and even just use some language that says, we'll use best efforts to get you a 3-year term, but it's going to be subject to bank financing. At least then you're setting the stage for your seller that, hey, you know, some of what we're promising here is subject to me being able to finance this deal to buy your company in the first place. Then oftentimes the seller notes have set-offs, so you can, if you have an indemnification claim, you can set off to reduce the principal amount of the note, and use that instead of actually having cash exchange hands. Again, some banks take a different view on that. They say, well, no, we want you to pursue that claim and get that cash and use it to repay the senior debt. You know, we try to argue hard against that. Like, hey, if we can reduce your sub debt without an actual principal payment, you're not in any worse shape. The counter to that for the bank is, I paid for that. It's not really what we, you know, I helped you pay for that. The value isn't there. Get that money back. So, seller note defaults. Again, this can be a very kind of emotional thing, and you need good counselors to advise. Certainly payment default. If you miss a payment, that's going to be a default under the seller note. Bankruptcy, insolvency events, there should be no debate about those types of events. Those should be defaults under your seller note. The sale of assets, change of control. Again, those, you know, me seller, I'm doing a deal with you. If any of those change of control type transactions happen, I should be able to declare a default. Beyond that, it can get dicey because, again, you're going to, if you're assuming there's seller financing, the senior debt is going to have a cross default to the seller. And usually the senior debt will not allow the seller to have a straight cross default to the senior. They're only going to have a payment default. So the seller note would say if you miss a payment on the senior debt, that's a default under the seller note, but not just any generic default. So I bring this up because if your seller note, if you want to add a bunch of covenants that say, I need financial statements and I want to have the same bank covenants. Well, if there's a default, on some level, all you're really doing is blocking your own payments in the future, because now you've tripped the senior, and the senior subordination agreement is generally going to say, once we're in default, you don't get paid anymore. So again, this can be an emotional thing for us. What do you mean I can't get information? What do you mean I can't get financial information? But just, again, counsel your sellers that hey, maybe you don't really need it, and here's why you might not want it. And then security is also a big, we do see a lot of secured seller notes. Sometimes they get a general business lien on all the assets of the buyer. If it's a stock deal, it might be limited to the stock being acquired or sold, or the assets being acquired and sold in an asset deal, or again, unsecured. And I'll talk a little bit more about the security interest in a bit. So again, information rights and covenants, I kind of covered some of this earlier on the default thing. So again, just, I mean, certainly if the sellers negotiated it, they're entitled to them and should get them. But again, I sometimes question the utility of them, even when I'm counseling sellers, because it's like, okay, you got all these great rights, but you know, you've got a cross default to the senior, so if the note trips, you're just really blocking yourself from getting paid, and you know, sometimes you want to make it as easy as possible to get paid. So if there are financial covenants, I mean, if you do get a seller note that has that, and quite frankly, I rarely ever see that ever, because I mean, again, most sellers aren't like a bank. They're not underwriting a deal. They're not looking at cash flow. They're not, you know, your seller's not making those determinations. But if they're there, they're usually cushioned off the bank. So if the bank's at 3-3 or 3 times leverage, the seller note should be at like 3.3 or something that's looser, so that it's not a straight cross default. They should have to perform, the buyer should have to perform marginally worse before you trip that financial covenant. That'd even be the same for institutional mezz debt. The senior is going to want some cushion off of those financial covenants. One covenant I do think not a lot of sellers ask for, but I would say it's a fair ask, is a no dividend. You shouldn't be, the buyer shouldn't be able to take dividends out of the company while the seller note maybe is being, or at least the seller note has to be in good standing before the dividend can be paid. You shouldn't be able to like bleed money out. The ownership shouldn't be able to bleed money out while the seller note is being blocked or not being paid. So subordination agreements. Subordination agreements, high level, the seller note is subordinated to the senior bank debt. The most basic forever says no payments whatsoever. I mean, you will see like you can't ever get paid. That's generally not fair, right? What you usually see is absent a default, regularly scheduled payments are permitted. Your interest payments are permitted, your principal payments are permitted. If you have those balloon payments or that bullet maturity, that may or may not be permitted. But it's generally regularly scheduled. And then the senior lender has the right to block those payments and turn them off. Certainly if the senior lender is not getting paid, the seller isn't going to get paid. It's just the way it is. There's no, I haven't seen one any other way. And the seller doesn't start getting paid again until the bank is getting paid. Because again, the bank's above the seller. So you got to get right with the first debt on the capital stack before you can get right with the second. Then you get into the other defaults, financial covenants. Can we block? Generally, yes, because again, if the financial performance is sliding, the bank may want to step in and say, hey, you're in covenant default. We can't keep having you service X amount of debt a year. That's got to stay in to help service our debt. Then you get into the other, if you think about a credit agreement that you have with a bank, there's 30 pages of covenants, right? Got to pay your taxes, got to maintain your insurance, got to send me financial reports, borrowing-based certificates, no debt, no liens, no. So the question is, you have what some sellers might think are foot faults. Well, can you just turn off a payment because I'm 5 days late on my financial statements, or because I contested a tax lien and I've got a lien that popped? You know, those are generally open for some negotiation. But again, the bank's initial position is going to be any covenant default, you're not paid until that covenant default is addressed. What you can see is some limits on those non-payment defaults. Like for mezz debt, it's usually 180 days. Seller notes, you know, meaning, hey, even if I'm late on if I trip this June financial covenant, after 180 days, if there's no other defaults, I can start getting paid again. You bank need to, if you don't like it, do something about it in that 180 day or 360 day period. And the bank can do something about it. They can always turn a covenant default into a payment default, because if you've defaulted with the bank, they can accelerate. And if you don't pay them off, you've now had a payment default. So a bank can always turn a covenant default into a payment default if they really want to shut off a seller. So again, that sort of works back the other way when you're working with a seller to say, just so you know, if you want to put a time limit on the block, we can do that, but it might force the bank to do something it may not want to do, meaning accelerate. And then again, you're not going to get paid until the bank is fully paid out at that point. But to your point about, that's a lever a seller can use. Hey, you bank, I call it the shit or get off the pot. Like, it's been a year. Like, waive the default, let's move on, or let me start getting paid again. We got to do something here. If a seller takes a payment that they're not entitled to, they are obligated to turn it over. So that's the, you know, the credit agreement will require the borrower not pay. The subordination agreement gives the bank the contractual right to go against the seller who received the payment, not just the borrower who made the invalid payment. They have the right to go and say, you took that payment, you weren't entitled to it, turn it back over to me. So we've got how long can my payment be blocked is one piece of the equation, and then the other one is how long am I stood still from taking action as a seller? Okay, so I've got a default, either a payment default or some other default under my note. How long before I can sue? Banks, again, the default position is generally you can't. You can't ever sue until the senior debt's paid in full or the senior lender is also suing. Because again, the senior doesn't want someone below them in the debt stack kind of forcing them to make a decision earlier than they need to. This is also negotiable, and usually the time period, if there is going to be a time period, it aligns with your payment block, right? Okay, I've been blocked for 360, I've stood still for 360, now I'm going to take an action. Again, it will just force the bank to take, or the senior lender to take action right in front of you and to run their process. And then while there's if you're in a bankruptcy proceeding, the seller note doesn't get paid until the bank is fully paid in full. At that point, everything's blocked until the bank's out. Security interests. So just a couple of things. Generally, the goal of the security interest, I think, should be to get the seller ahead of general unsecured creditors if there is going to be something negative. It's not really to give them sort of typical lien rights that a bank would have. I mean, they get lien rights, but it's really just to move them up the debt stack in a bankruptcy, meaning the bank is going to say, you get this lien, but it's a silent lien. If the borrower wants to sell an asset and comes to me, senior lender, and says, release the lien, seller, you have to do that as well. You can't use the lien as a way to frustrate our normal interaction with the borrower, or to otherwise disrupt. So you get the lien, you're in front of general unsecureds, but you don't get blocking rights, you don't get to assert some of the other bankruptcy protections that a secured creditor would have. The senior lender gets to run its process. But it is still beneficial because you are in front of the general unsecured creditors then if there is a bankruptcy. So after the bank is paid in full, since you're the next secured creditor, you would get paid next until there's nothing left or until you're paid in full, and then everything else goes the unsecured. Obviously that's high level, I mean, assuming there's no actual reorganization. Other things you'll see in a subordination agreement, and again, these have, these debates come up frequently, is what about a cap on senior debt? So if you're a seller and you know that your borrower, your buyer is going to take on 15 million of senior debt. Well, what if they want to do an acquisition in year 2 and they're going to borrow another 15 million of debt and they want to layer that on top of your on top of your note? Or do you get to say yes? Do you get to say no? These are heavily negotiated points, because the seller might say, look, I'm agreeing to subordinate to 15 million. the buyer's going to say, you don't get to run my business. I bought the business from you, and if the bank has done an underwriting on this and has determined that the combined new entity can service this debt and do this, you should let me borrow the money. You don't get like a super board seat, if you will. I mean, it's almost like giving a majority. You see that ability to extend maturity date. Again, what if the bank does that initial 5-year deal and says, okay, in year 3, we're going to kick out another 3 years? Well, if they can block a balloon payment at maturity, or if your fixed charge has that a balloon payment all of a sudden drop into your denominator, how do you work around that in terms of getting the seller financed out? So we will sometimes see, like, okay, you can't extend past my maturity date. For a senior debt cap, I mean, if it does come up, I usually try to argue something ridiculously, if I'm the borrower, right? It's like, okay, fine, we'll agree to 2.5 times the debt at close. So you get some protection that I can't take it to, $100 million, but at least as a borrower, you can run your business. As a senior lender, you don't have to worry about if I need to make a protective advance or if I need to do, some short-term financing. Is it senior or not? And can I get my seller to sign up? Same thing with change in interest rates. If you're SOFR plus 2 with your senior debt and you struggle a little bit and the bank says, well, I want to take it to SOFR plus 4. Well, theoretically, you didn't agree to subordinate to that interest rate. You agreed to, and that debt service, you agreed to subordinate to something else. So these are all negotiable points, generally favoring the senior lender and borrower, I'd say on the whole. You don't get to, you don't win a lot of these restrictions, is generally what I see for sellers. The one I would say is fair is you can't impose additional restrictions to pay the seller note. Like that is a fair bargain, right? Like you can't close and then amend the credit agreement 2 days later to say, I can't make a payment on the seller note for 6 months. It's like, well, hey, I didn't, that's not sort of what the seller bargained for there. Final note, make sure your definition of senior debt isn't so broad that it might capture something that is unintended. Again, in a standard Laser Pro or WBA document, it'll say subordinated debt means all obligations, debts, and liabilities from buyer to seller. Well, what if seller's rolling over equity and you pay a dividend? Can the bank claw that dividend back? What if it's an individual seller and they're an employee and they get paid wages and salary? I mean, read literally, that's an obligation to pay, So you need to be mindful of how broad that definition is, or limit it to what you mean. It's the note. That's all it is. We're not subordinating anything else. And, if the seller's rolling over some equity, why should they subordinate that equity position when none of the other equity holders are subordinating? Just because they took a seller note back? So, again, just make sure that your definition, you're capturing what you intend to capture, and you're not so broad that you give a bank an opportunity if things do go wrong to say, oh, and by the way, you've got this, you took a little management fee, or you had a consulting payment, or you got an earnout payment. We thought that was all subordinated, even though that was probably not the intent at the start. So I think with that, that's my portion of the presentation. Any additional questions? Yes?
Was the transaction type, whether it's stock or asset or industry of the transaction, have any influence on the combination of these different payment methods?
I don't think it's really industry specific or deal specific. No, not. It's really how I find it more how sophisticated your senior lender is. Senior lenders that have sponsor groups or private equity groups in their banks are far more sophisticated on these than like and it's not a knock on a smaller community, than on a community bank that might, it's the regular lender that's going to provide the financing for it. Since they don't have the exposure to these things, they might not be thinking about some of the things like a leveraged finance capital group might. So I think it's more the bank and the depth and breadth of the lenders that you're dealing with. All right, well, I think we're kind of right at 5 o'clock anyway, so appreciate you all coming, and thank you much.